Hello, everyone. If you're just joining us, we're going to wait just a couple of minutes while everyone trickles in here. Please just hold on for a couple of minutes and then we'll get started. Okay, I think we'll give it just one last minute and then we'll get started this morning. All right. Good morning, everyone. Thank you so much for being with us today. My name is Shireen Poti, and I'm a Senior Associate in Jones Day's Global Disputes Practice. I'm coming to you live from Paris, France. And on behalf of the Campaign for Greener Arbitrations, as well as Jones Day, it is my distinct pleasure to welcome you to this first global launch session of the Green Protocols. The Campaign for Greener Arbitrations is an initiative to reduce the environmental impact of international arbitration. It was founded by international arbitrator Lucy Greenwood in 2019 with the aim of significantly reducing the carbon footprint of the arbitration community. In 2020, the Campaign for Greener Arbitrations established a steering committee comprised of members of the arbitration community, including practitioners, institutions, and legal service providers, who each have a stake in the continued improvement of international arbitration. A fundamental objective of the steering committee was the establishment of a framework and a set of protocols to promote better environmental behavior through a series of action items. Through the efforts of a dedicated working group, which you see on the screen, we recently launched the public consultation phase of our draft framework and Green Protocols. Today we have two objectives. One is to make you more familiar with our 6 Green Protocols, their accompanying framework, and our model Green Procedural Order. The second objective is to solicit your feedback. As we are currently in our public consultation phase, we are seeking your input on the content of the draft. We have therefore designed this webinar to be as interactive as possible. We encourage you to actively participate in this session by giving your live feedback in our chat box. We are eager to hear your comments and impressions on the draft protocols and your thoughts on the various topics covered. To get you started, could you please go ahead and post a quick line in our chat now, letting us know from where you're joining today. Feel free to submit anonymous feedback in a private chat to any of the presenters here today. You may also email feedback if you would like to the email address protocols@greenerarbitrations.com until mid-March 2021. If you have questions during the webinar that you would like to ask our speakers, please submit them in a separate Q&A box at the bottom of your screen. It's not the chat, it's a separate box, and you can access it by clicking in the panel, the three dots on the bottom right of the page, and selecting Q&A. We will have a brief Q&A at the end of the session, and please make sure to send your questions to all and not to anyone individually. Lastly, we will be soliciting your participation through a series of poll questions, which we will put up throughout the session. We look forward to hearing your responses and are very excited to have you all here with us today. One last housekeeping note. For those not so familiar with the WebEx application, on your screen you will see our slides and/or the video of the speaker presenting. Feel free to adjust the layout settings to side by side in order to see both at the same time, and drag the divider to the left to have a view which is evenly split. For your information, the slides will be available to the participants after the event, and this event will be recorded. We are thrilled to have a very large number of attendees signed up for our 2 global sessions. The latest count revealed over 350 attendees for the 2 events. We are very excited about positive feedback. Registrants hail from all parts of the world, as you can see in the graph before you and in our chat. We intend to make this public consultation phase as regionally diverse as possible by holding throughout the month of February a series of interactive regional sessions designed to engage key players in each region. Please be on the lookout for further communication in that respect. Now for our first poll. Full question is, what is your primary affiliation, arbitrator, law firm or chambers, institution, hearing venue, conference organizer, in-house, student, or other? Please take a couple minutes to answer the question. Well, I'm having some trouble seeing the results. Christine, do you have them before you?
Me the results either. I can just see that people have answered, so that's some good news. But it does look like the, I can see some here. Okay, so we're showing that about 57% of the audience has attended a virtual hearing, and we're at about 43% who have switched over to some greener energy sources for their energy. Okay, I guess we're getting a comment that the poll maybe wasn't working correctly. I think we put up one of the other ones. So maybe perhaps what we can do is just move along to the next slide, and maybe when we catch up on our next poll, it'll go more smoothly.
Apologies for the technical difficulties here. Well, let's move on. So Apologies, 1 second. Please.
And I think, Shireen, we just need to advance the slides a bit. I'm seeing the first slide.
Are we caught up there? Can everyone see the next slide?
We're still on slide 1. But perhaps what we can do while we're working on that, I've listed in the chat the access to the Greener Arbitrations website as well. So be sure to have a look over there. We'll post it again so you can go and, here we go, we're catching up now. There you go.
Okay, apologies for the difficulties. So now it is my distinct pleasure to introduce my colleague, Linda Hess, a partner in our capital markets practice here at Jones Day, also based in our Paris office. Linda advises clients in the areas of capital markets, securities law, public M&A, and corporate governance under both U.S. and French law. Her practice includes advising on environmental, social governance, or ESG matters, including sustainable finance transactions, green frameworks, ESG disclosures, and risk assessments. Linda is an active member of Jones Day's ESG working group. Thank you for being with us today, Linda.
For putting this together, and thank you so much to the campaign for Greener Arbitrations for actually doing some of the really substantive work that we all need to do in changing the way that we do business. Lucy Greenwood has been, I think, taking a lead on this along with the steering committee, and I think this is what we need to see for us, for all of us, both in the way that we do our work and, of course, the way that we're going to be making the green transition. Jones Day is very happy to be part of this campaign, and we're pleased to be here with you this morning. We recognize the importance that the campaign is seeking to highlight, and we actually believe that this is the way that we'll be able to make change more generally. We're working with our clients on all of the necessary transition to meet the net zero goals that we've set for ourselves. And we think that it's important that we undertake it in our own work and that we push what are new and innovative ways of doing business. So thank you very much for having me here this morning, and thank you very much for organizing it and doing the heavy work. We're excited and honored to be a part of this initiative.
Thank you so much, Linda. Now I am very pleased to introduce the founder of the Campaign for Greener Arbitrations, Lucy Greenwood. Lucy Greenwood is an independent arbitrator specializing in commercial and investment disputes. She has practiced international arbitration since 1998 and has acted as arbitrator in more than 50 arbitrations since becoming a full-time arbitrator in 2017. She is highly regarded for her prompt, efficient resolution of disputes and active case management of arbitration. She is a chartered arbitrator, a member of the State Bar of Texas, and a solicitor of the Supreme Court of England and Wales. Lucy Greenwood is listed on all major arbitration panels, as well as on Global Arbitration Review's arbitrator research tool. She is a trustee of the Chartered Institute of Arbitrators, past chair of the International Committee Dispute Resolution section of the American Bar Association, past chair of the North America branch of the Chartered Institute of Arbitrators, and a fellow of the College of Commercial Arbitrators. In 2019, Lucy Greenwood launched what she termed her Green Pledge to minimize the impact of her arbitration practice on the environment. The Green Pledge caught the attention of the wider arbitration community, and soon hundreds of individuals signed up to the pledge. Lucy realized that while the Green Pledge worked for those who practice as arbitrators, the arbitration community was keen to get behind a broader campaign to address waste and unnecessary travel that often occurred in international arbitrations. As a result, she brought together representatives of key stakeholders in international arbitrations to spearhead the Campaign for Greener Arbitrations, We are very excited to hear your insights today.
Thank
you, Christine. And if I could just remind everyone to mute themselves. Well, good morning, everyone. Good, very, very early morning to those of you who've got up in the US. We really appreciate it. It is so inspiring to see the traction that this campaign has gained recently, and to frankly see so many of you taking time out of your Friday to listen to what we're going to tell you today about the Green Protocols. But before we get into the detail of the session, I just wanted to give you a little bit of background into the Green Pledge and the campaign, and really just sort of set the scene a little bit for you. So, as many of you know, I spent 10 very happy years living and working in Texas, and it's so nice to hear Shireen mentioning that I'm a member of the State Bar of Texas, of which I'm extremely proud. And, you know, from my office in downtown Houston, on a clear day, I could look and I could see the refineries out on the Gulf Coast. And when we've been away for the weekend, we'd drive back along the freeway, and I loved looking at the nodding donkeys. I drove 30 miles to work every day in my Dodge Grand Caravan minivan, and I filled it up with gas at $3 or less a gallon. All my clients were energy companies. All my work was hydrocarbon-based. And I saw my clients evolving, embracing ESG principles in their practices, and I didn't really take any notice of it. My job was to decide their cases. My job was to advise them on their disputes, really nothing more. And although I really thought I was quite environmentally aware in my personal life, professionally, it was really kind of someone else's problem. And there's a fairly trite saying which goes something along the lines of all you have to do is wake up and change. And for me, I woke up and changed back in 2018 when I was chairing a major energy arbitration in Houston. And at the end of the hearing, I looked at the wall of printed documents behind me, and I realized not a single binder had been opened during the course of the previous 2 weeks of hearing. And really, everything had been done on screen. And, you know, to my credit in that case, I was chairing the matter, as I say. I had insisted on electronic bundles. But with my co-arbitrators, we were cautious, and lawyers always are. And we said, well, we just have a printed set, just in case the technology didn't work. And that wasn't good enough. It wasn't good enough to do that. So at that moment, I began to look at the available technology and basically examine why I thought the technology might fail. And all the technology was there. I looked at it and I couldn't understand why. An arbitration that I was conducting in 2018 really looked very, very similar to my first arbitration in 1998. Frankly, all that had really changed was that the submissions had got longer, as we all know. And so the technology was there, but we weren't using it. We weren't embracing paperless arbitrations. We weren't taking advantage of video conferencing to deliberate remotely as tribunal members, or to use it more in a more sophisticated way for witnesses. It was certainly there. It was there to help us run arbitrations in a more efficient way, in a more cost-effective way, and fundamentally it was also there to help us reduce the carbon footprint of an arbitration. And we just weren't using it for any of those purposes. So, as Shireen says, from then on, I put my hand up and said, as many of you know, that I would endeavour to run my arbitrations in a more environmentally friendly way, and I would encourage parties appearing before me to do so as well. And from then on, the Green Pledge was born, and then the campaign evolved from there. And you know, I cannot thank enough the amazingly committed and dedicated steering group members. We have over 40 people from all across the world, a highly diverse group of individuals who have really brought the campaign to life. And although there is going to be a fair bit of talking today, let's be clear about this. Today isn't about talking. Today is about action. And as an arbitration community, we are really good at talking. We love talking. Before we were all confined to our homes, we would not think anything of jumping on a plane to go to conferences all over the world, speak at conferences, listen at conferences, sometimes pretend to listen at conferences, network, socialize. We loved it, and we knew we were fortunate. I don't think I have ever been in a job where people have so obviously loved and been passionate about what they do. But we were fundamentally insulated from our behavior, and I really think we were pretty blind to its consequences. So today isn't about talk, as I say. Today is about action. It's about how we build on the steps many of us have already taken to reduce the impact of our arbitration practices. And I really don't want to see the Green Pledge being debated at conferences. I want to see it being lived. And the Green Protocols today are there to help us do that. They're a start. They are very much not the complete answer, nor are they in any way perfect, although frankly what the working group have done in an incredibly short space of time is absolutely phenomenal. But they are simply a roadmap to change. They're nothing more than that, and I don't want us to lose sight of that. They are a guide for all of us to change. So signing the Green Pledge isn't enough, nor is talking about it, nor is spending time arguing whether a high-value arbitration has a larger carbon footprint than a low-value dispute, or we just don't have the luxury of that time. You don't need me to tell you all how wasteful the practice of international arbitration can be. I can hit you with data and statistics. I can talk about the tons of carbon that each arbitration is responsible for, the long-haul flights, the mountains of bundles, as I say, the unnecessary travel to the unnecessary meetings. But fundamentally, I think deep down, we all knew how wasteful our practices were. We just all thought it was somebody else's problem. And also we quite liked the glamour of it all, and frankly I miss seeing everyone in person now, as we all do. But we're now in a climate emergency. And we have to do two things to respond to that emergency. We have to mitigate and we have to adapt. And I think we've actually all been really surprised. Certainly I have, being a real cynic sometimes. I've been really surprised as to how, as a community, we've adapted to the pandemic and how we've pivoted really pretty seamlessly to virtual hearings and to conducting events online such as this one. And so many people have come up to me and said now they're real converts to electronic bundles. And I've rarely been prouder than I chaired a hearing even before the pandemic, and I saw all three arbitrators all sitting there marking up our documents on screen. There's real converts to the idea of reducing travel. And this is absolutely vital when you think that 93% of our emissions from international arbitration are a direct result of flying, particularly business flights. So the pandemic has shown us that we can adapt our practices to mitigate climate change. And the change to our working because of the pandemic is the biggest change I have seen in international arbitration since I began practicing almost 25 years ago now. But my point is we didn't endlessly debate it. We didn't agonize over which was the best online platform, all the complexities. We just got on and did it because we had to, because there was no alternative. And being very, very frank with you all this morning, I don't think that we have an alternative now. We have to reduce our carbon footprint. We have to each take personal responsibility for that. And we have to change. And we can do it for many, many reasons. We can do it to stay relevant. We can do it to be more efficient. We can do it to please our clients. We can do it to deal with our guilt. We can do it to appeal to new hires. We can do it to reduce costs. It really doesn't matter why we do it. What matters is that we make that change. And you may sit there and think that refusing to use hard copies or to reduce the number of hard copies you produce in your next arbitration won't make a difference. It will. choosing to take one witness over video rather than flying a team of lawyers to interview them will make a difference. And we all have to understand that it is those small steps that do add up to a very big change. So in my mind, using the Green Protocols, adapting them as you see fit, picking and choosing from the bits that you want to do, leaving the ones that don't work for you, it's fine. But using the Green Protocols isn't really a choice. It's an obligation. And the working group have done such a tremendous job in putting these roadmaps together for us. That's what they are. They're a roadmap. And without being too trite about it, to use a trite word, it's the start of a journey. And I am really, really excited to see where we can get to as a community. And so with that, let me hand you back. I think I'm going to hand you over to Christine, who's going to really help you understand that roadmap so that we can all move towards real sustainable change in our community.
Thank you, Lucy. Actually, I just have a couple more things to say, and then it will be over to Christine in a moment. Thank you so much for those inspiring remarks and for giving us the background about the history of the campaign and how these initiatives are so very important. I am now very pleased to introduce you to the distinguished panel of members who make up our working group of the campaign, which Lucy just referred to, dedicated to the establishment of the Green Protocols, and who will be further acquainting you with them. So may I first introduce you to Christine Salciccio. I think I pronounced it correctly. Christine is the founder of Sopra Legal, a woman and attorney-owned company that specializes in the creation of hyperlinked submissions. She works with law firms and clients globally to transform traditional paper submissions into interactive digital presentations and e-bundles. Christine has published articles and consulted with U.S. federal and state courts, as well as other organizations, on best practices in the development of procedures for paperless filings. In addition to her work on the steering committee of the Campaign for Greener Arbitrations, Christine is a member of Arbitral Women, the international law section of the Florida Bar, and Seton Hall Law School's Women's Leadership Advisory Committee. Next, we have Sarah Vassani. Sarah specializes in international commercial arbitration and investor disputes. She heads Adelshaw Goddard's investor state dispute resolution practice, advising investors and host states alike. She is qualified in the U.S. and the U.K. and is recognized as a global leader by Who's Who Legal Arbitration 2021. Sarah represents clients before all major arbitral institutions and in arbitrations conducted under the UNTITLed rules and foreign investment laws. She regularly advocates for her clients' interests before tribunals and advises clients on investment restructuring strategies for minimizing the prospects of full-blown disputes. Sarah is an adroit counselor on managing and sharing the risks of arbitration through third-party funding, ACA insurance, CFAs, DBAs, and enforcing arbitral awards. Sarah regularly sits as a party-nominated sole and presiding arbitrator and is on CI Arbitration's Business Arbitration Scheme panel. She is passionate about mentoring, diversity and sustainability in international arbitration, and is part of the protocol working group, as we mentioned, of this Campaign for Greener Arbitration Steering Committee. Next, we have Maguelone de Goudier, who is a senior associate in Herbert Smith Freehill's global arbitration practice. She is based in London, but has also practiced in Paris and Tokyo. Maguelone specializes in commercial arbitration with a particular focus on energy, commodities, infrastructure, and transport. She is currently on a secondment to Standard Chartered Bank's Disputes and Government Investigations legal in-house team. Maguelone is passionate about diversity and sustainability in arbitration. She is part of the working group, as mentioned, and is also the co-chair of the ERA Pledge Young Practitioners Subcommittee, formed earlier this year. She is also on various internal Herbert Smith Freehill's diversity and sustainability working groups and regularly speaks and writes about the topic. Next, we have Kiran Sanghera. Kiran is special counsel at the Hong Kong International Arbitration Center. She currently leads HIAC's domain name dispute resolution team and oversees its business development initiatives. Kiran has also previously worked in the center's arbitration team as legal counsel, handling the administration of commercial arbitrations involving parties from Asia, Europe, and the Americas. She has been responsible for drafting and implementing internal guidelines for case management and regularly delivers presentations on the work of the center and broader issues related to arbitration. Kiran has also worked as Director of Litigation Funding at Harbor Litigation Funding, where she was responsible for developing third-party funding market, the third-party funding market across Asia. And she has also spent time at the Secretariat of the ICC International Court of Arbitration in Paris. Kiran is the past co-chair of HK 45 during the 2018 to 2020 term, and she currently sits on the steering committee of the campaign, as mentioned previously. Given her experience, Kiran brings a 360-degree perspective of the workings of an arbitral institution to the work of the campaign. Rekha Rangachari is the executive director of the New York International Arbitration Center, NIAC. Founded in 2013, NIAC is a not-for-profit, non-governmental organization that promotes and enhances the conduct of international arbitration in New York. In her role at NIAC, Rekha collaborates with stakeholders and thought leaders in the space to advance scholarship and best practices. She offers educational programming, events, and trainings, and operates world-class hearing facilities in Midtown Manhattan. Rekha is actively engaged with the arbitration community at the city, state, national, and global levels. On the global level, Rekha is a board member of Arbitral Women and its Diversity Toolkit Training, Cooperation, and Events Committees. She is a member of the Equal Representation in Arbitration Pledge's Young Professional Subcommittee and a steering committee member of this campaign for Greener Arbitration. Rekha also maintains an active connection to academics as the associate editor of the Juris Investment Arbitration Conference volumes, an adjunct professor at Seton Hall Law School, and a peer review board member of the American Review of International Arbitration at Columbia Law School. We are delighted to have all of our panelists here with us today. I will not endeavor to introduce myself, but simply remind you my name is Shireen Poti, and I am a senior associate here at Jones Day in its global disputes practice based in Paris. So now it is finally Christine's turn to take it over. I will turn it over to her for a further look at the Green Protocols and their accompanying framework.
So now I would like to get into the whole reason why we're here today, and I'll tell you a little bit of an overview. So again, I thank you for joining us. And before we get into the details about the Green Protocols, I would like to share a little bit of the background of our drafting process and to outline the focus of each protocol. After I do so, my co-presenters will provide a deeper dive into each of the protocols. Our working group formed in early 2020 with the goal to develop a practical set of steps to accomplish the campaign's guiding principles, which you see displayed here on the current slide. We sought to create a concise set of directives to guide members of the community in the effort to reduce their environmental impact of the international arbitrations. Turning to the next slide, we started to focus our work just as the world was shutting down due to the pandemic. So we share this image as a really compelling visual to show you what a striking scene we saw once we began this work, and we saw how the lockdowns showed an immediate change in pollution. I wanted to remind you that our actions have immediate consequences, and images such as these, which I'm sure you have seen, really prove that. Now, I am in no way advocating that we remain in quarantine any longer than deemed necessary, but as we do emerge and approach a more hopeful time and begin our new normal, now is perhaps the perfect time to implement changes to our working environments rather than returning to the status quo. We did plan to include a poll next, but I don't know, Shireen, if we might just bypass that. I'll defer to you, but I think it might be best to just go ahead. We do have a lot to cover anyway, so let's just maybe move on to, we'll go right past that. And we might fill you in on those facts a little bit later. But for now, with that, let's go into the introduction to the protocols here. So what we would touch on in the slide was we were going to make you guess these options, but here I'll just give them to you. We've decided to focus the campaign on these three critical areas, and I know Lucy touched upon this in her introduction as well, but our main focus is on the areas of adopting more clean forms of energy, reducing long-haul travel, especially as we begin to emerge and return to the option to do that, and finally reducing waste, in particular eliminating hard copy filings altogether whenever possible. So you will see practical steps to address each area throughout the protocols. Next, I tell you about how our initial work focused on the conduct of arbitral proceedings themselves, and we considered several approaches for the additional protocols, with the ultimate decision to address specific stakeholders. The final result is our collection of 6 unique yet related protocols that propose sustainable measures. Each protocol is intended to be adopted individually or in combination as appropriate. And we also include a model procedural order, which we'll touch on as well. To help you navigate through the protocols, you should begin with our document entitled The Framework for the Adoption of the Protocols. And if you recall just one item from my points today, when in doubt, begin with the framework. This document is your roadmap to help you navigate through the protocols, and it will provide additional insights into the interconnect of all of these files. A little fun fact that the framework was actually the last file that we drafted. We had this series of related but separate protocols, and we recognized the need for a central and unifying document. And with that, we came up with the framework. So again, I urge you to begin there when you review our protocols. Moving on to each of the 6 protocols. Their titles rather clearly indicate the intended stakeholders, and many of you may seek guidance from several of the protocols. Our upcoming speakers will provide additional instruction on each file, but for now, I begin with an overview. First, we have the Protocol for Arbitral Proceedings, and this is a series of measures to implement in an arbitration. Accompanying this file, we created a separate model procedural order that includes draft language that can easily be inserted by tribunals into their procedural orders. Next, we look to guide law firms, chambers, and legal service providers by extending our guidance to daily operations of these firms. And I note that while this file will ideally be adopted by entire organizations, it most certainly may be initiated on an individual level as well. So please keep that in mind. Next, we turn to the Green Protocol for Arbitrators, which focuses on suggested conduct for individual arbitrators throughout a proceeding. And then the Institutions Protocol, which suggests action items for these arbitral organizations. We then extend beyond to the wider community, where we have 2 more protocols. First, the Protocol for Arbitration Conferences, where we encourage those who plan such events to do so with an eye toward greener practices. And then our last protocol for arbitration hearing venues. And there we target hosting facilities with advice on minimizing their environmental impact. Again, my colleagues will touch more on each of those. But in general, we next turn to tell you about how we noted earlier that we carry unifying principles throughout all 6 of the protocols. And the areas listed on this slide you see now are repeated with some variation and additional instruction throughout most of the protocols. We identify practical ways to adhere to sustainable measures such as those listed here, particularly those relating to clean energy, waste reduction, as well as others like social responsibility considerations. As individuals and organizations begin to implement the suggested measures, we highlight some considerations, as you'll see on the slide here. Once again, these items may be reviewed in more detail in the framework file, but I highlight the importance of some of the items, such as diversity considerations, as well as costs and efficiency, among others. So definitely have a look at that when you review the framework. It is important to note that the content of the framework and the Green Protocols and your support of this initiative is in no way intended to deviate from any existing arbitration agreements, orders, or applicable rules. We share this guidance as part of a larger effort of a voluntary agreement among the arbitration community to shift behaviors and begin to act with the continual thought of the impact of our behaviors on the environment. The collective effect of even small shifts in behaviors, particularly in terms of travel and energy, will for sure have a tangible impact when practiced by this global community. We challenge you to stretch beyond your comfort level now and push for changes that may seem inconvenient or even tough, but will ultimately lead to a better future. With that, we then turn to you, the community. So during this consultation period, while we're not seeking a complete rewrite of the materials we've provided here, we do ask that you review the measures and share your thoughts with us. Perhaps you'll identify a suggestion that we may have missed. And in particular, we'd like you to focus on the tone. We were wondering whether people would be more receptive to having a mandatory or an opt-in tone, so please consider that. We will share more about our requests later in the presentation, but I ask you to keep these items in mind as we touch on each protocol. Now, before I turn it over to my colleagues, we were going to have one more poll. I think again, we'll probably skip past that, but Shireen, we can show the slide with the answer, perhaps, and give you a little bit more information on that. We were asking about if you had any thoughts on the number of trees it would take to offset the total carbon emissions from just one arbitration. Now, those of you who have visited our website or maybe have heard Lucy speak recently at all may already be familiar with this figure, but it is quite astonishing when you think about it. I mean, really contemplate that the results of a study that the campaign conducted on a medium to large scale arbitration projected that just under 20,000 trees could be required to offset the carbon emissions of just one arbitration. I think we should just let that sink in and think about that as we now move on to have a closer look at each of our protocols. So with that, I will return it to Shireen to give you more insight into our arbitral proceedings protocol. Thank you.
Thanks so much, Christine. Hello again, everyone. I will be presenting to you the first draft Green Protocol, the Green Protocol for Arbitral Proceedings. So this draft protocol concerns the behaviors of parties and arbitrators and suggests very tangible measures which can be implemented in specific arbitration proceedings. As Christine mentioned, in Section 1 of this protocol, and if you could just please, everyone, make sure that you're on mute because there's some background noise. In Section 1, this protocol leaves the adoption of the protocol open to the parties or arbitrators. They may either choose to adopt the entirety of the protocol or only adopt component parts of it as best fits their particular arbitration. In addition, they can either adopt its content as mandatory provisions or simply as guidance. The parties and arbitrators have free will to decide on those choices. So it is possible that a tribunal could decide to include such provisions in a procedural order, and for that purpose, we have a model procedural order with draft language which can be implemented by tribunal members. We also have, throughout this Green Protocol for Arbitration Proceedings, specific sections which highlight where the draft protocol language where the draft model procedural order language can be found and can thereby be inserted into procedural orders of tribunals. Parties could also decide to adopt such provisions in their arbitration agreements prior to the commencement of an arbitration, either, once again, as guidance or as mandatory provisions which should apply. Aside from these initial commitment notes, this Green Protocol also addresses the various phases of a typical international arbitration proceeding and the types of behaviors that may be adopted by parties or tribunals during such proceedings to reduce their environmental impact. Section 2 of the protocol discusses the conduct of proceedings. So a default rule is established for electronic communications and correspondence, and for the use of shared technology platforms and electronic annotation of documents, as Lucy referred to earlier as a tribunal member. Printing of hard copies is discouraged, but where printing is necessary, actors are encouraged to minimize the environmental footprint of their printing, for example, by using A5 size paper, grayscale, double-sided settings, environmentally friendly toner, and ink, and or recycled or recyclable paper. The use of suppliers and service providers committed to reducing their environmental impact is also encouraged. For example, those committing to use green energy, reducing energy consumption, or avoiding the use of plastic or single-use items is encouraged. In sections 3 through 7 of this protocol, the various elements of a typical international arbitration proceeding are discussed. Written submissions and documentary evidence, document production, witness and expert preparation, hearings, documents are favored over hard copies. But where a tribunal expresses a preference for hard copies of written submissions, it should endeavor to limit printing only to the specific documents which it considers essential for printing, not the entirety of the case file. The creation and sending of USB keys is also discouraged given the implication of freight charges and the air travel, which is often a consequence of such sending. And parties are encouraged to reduce the possibility of duplicate exhibits being produced in their proceedings. Where documents are lengthy, the production of extracts is encouraged, and document production should by default be conducted electronically. The draft protocol expresses a preference for video conference consultation of witnesses and experts rather than in person. Where travel is required, the number of in-person participants should be limited, as Christine mentioned earlier. The draft protocol further stipulates that hearings generally, whether that be pre-hearing conferences, procedural hearings, or substantive hearings, should all be conducted by preference in a virtual manner, either by video conferencing or telephone. But where in-person hearings are required, actors are encouraged to adopt a number of measures. They should endeavor to use environmentally friendly travel options, avoid unnecessary travel, limit the number of in-person participants, for example, by allowing others to participate via video conferencing, consider using cross-examination via video conferencing, engage service providers such as court reporters and interpreters who are located in the place of the hearing, and use technology to display documents along with electronic bundles, as Lucy alluded to earlier. The draft protocol sets out similar standards for the conduct of settlement discussions between the parties. And lastly, there are two sections of the protocol, sections 8 and 9, which reiterate that unnecessary travel should be avoided. Where travel is necessary, travel options that minimize carbon emissions should be favored, and the need to fly at all should be questioned, given the disproportionately high carbon emissions which are generated from air travel. Where flying is deemed unavoidable, offsetting flights should be considered. However, given that behavioral change is the primary objective of protocols, offsetting should only be used to address residual emissions. These are our thoughts. We'd be very, very happy to hear your comments and feedback on these draft elements of our protocol. Please provide them in the chat. And now I'll turn it over to to Mag for the presentation of the Model Green Procedural Order. Thank you.
And thanks everyone who's joined us today. I'll be short on the procedural order, mostly because the procedural order tracks effectively the language in the Protocol for Arbitral Proceedings, which Shireen just helped run us through. Naturally, the wording of the procedural order is in mandatory form. Sorry, could I just repeat the previous request that I'll put on mute if they're not speaking? Thank you. Now, this procedural order is intended to act as a useful tool for those who are looking for readily drafted language to drop in procedural orders. It can be used in new or existing arbitration. And most importantly, echoing the point which Lucy made at the very start, the language in the draft procedural order can be adopted in full or in parts. Now, while it currently covers all of the aspects and sustainable measures which Shireen has just mentioned, set out in its framework. So as a reminder, that includes the applicable laws to the proceedings, the size of the proceedings, the ability of the arbitrators and the parties to comply with some of these requirements to communicate electronically, etc., the cost, as well as the effect that some of these sustainability measures will have on the efficiency of proceedings, on diversity, on confidentiality, etc. And of course, they can be adapted to take into account parties and arbitrators' individual preferences regarding procedural timetable and process. Now, I certainly would encourage everyone that is attending this webinar to look very carefully at the procedural order now to consider whether or not certain sections of it could be adopted in proceedings which are currently underway or proceedings which will have just been initiated. But I will flag that, of course, we are in a consultation phase, so the model procedural order will be amended in line with comments that we receive on the protocol for arbitral proceedings. And I will now pass on to Sarah, who I believe is about to introduce us to the protocol on law firms and chambers and legal providers.
Thanks much. Thanks for everyone for joining our global launch. Is everyone able to hear me okay? Okay, great. Well, I have the privilege and honor of cantering through the Green Protocol for legal advisors, which encompasses law firms, chambers, and legal services providers like tech providers and also independent court transcribers. Having looked at the list of attendees, it looks like this is for a lot of you. So please do listen up. I'm going to go through this relatively quickly. As you can see from the screen, this covers 13 different sections. And a lot of the information that was already provided by Shireen is also equally relevant. The initial commitment in Section 1 is to work within your organization to implement the protocol recommendations or to develop best practices based on the protocol. And because I know how busy you all are, we have suggested that this be undertaken either in conjunction with the leadership team of your organization or through the appointment of a green ambassador. Think of somebody who's super organized and passionate about this, who's really going to take ownership over this and make it happen. The idea here is to really make sure that there's accountability and also to increase the likelihood that these protocols actually get implemented. So to give some accountability to these protocols. The second and third sections provide recommendation and actions to use clean and renewable energy sources wherever possible, and also to reduce energy consumption of facilities and equipment. I think about these as the set it and forget it items. So they can really have a huge impact, but if you can do things like dimming lights and using electricity less, that really can have a massive impact on your overall carbon footprint. The fourth and fifth sections set out commitments to encourage the use of technology to reduce the use of paper, travel, and short face-to-face meetings. So this includes aims of providing staff with training how to use technology so that they can use tech as opposed to paper. and also to use technology effectively to speak with their clients or do things other than getting on planes. The sixth protocol, or the sixth section of this protocol, deals with something that all lawyers are familiar with, and that is the mountains of paper that we often create in the process of running an arbitration. I was listening to Lucy's conversation or her speech with a lot of memories about how many boxes were brought to every hearing room that were never opened, and that was always the case. I really think I have still residual back issues from all of those banker boxes. But this really deals with the encouraging all of us to minimize printing and the use of paper, and where printing's required, because I still do like to sometimes have a paper copy to use settings that reduce the environmental impact. Seventh and eighth sections deal with encourage recycling and reducing the use of single-use items like plastic bottles. In at number 9, we set out recommendations to partner with organizations that adopt the sustainable practices. This could be the printing services you use, and also using local service providers. So again, thinking locally, and if you need transcribers for a hearing, to get those from your own area rather than flying people in. At number 10, there's again something that we can all relate to. This section deals with recommendations to encourage people to travel responsibly, including thinking twice about whether travel is needed for a particular event or meeting, as well as putting in place policies that allow your staff to work from home. I think a lot of you are like me, where you always thought it needs to be a hearing in person, and I want to look into the arbitrator's eyes and really gauge the sense in the room. But I think at least for a number of those hearings, especially procedural hearings and ones that deal with discrete issues, we've all become comfortable actually with dealing with them remotely, and it can often be extremely more cost effective for our clients, and also we can get the job done in this way. So I think COVID, one of the very few good things that has come from it, is it has forced us to work in a virtual way, and I think it's showed us that this is actually quite possible, and for the right hearing and the right meetings, it can be an effective tool. At sections 11 and 12, we set out recommendations to incentivize sustainable behavior by staff, like subsidizing the purchase of electronic equipment so that they're able to work from home more easily, and also to encourage your staff to attend educational events about sustainability or to volunteer with organizations involved in sustainable initiatives. And last but not least, Section 13 of the protocol covers commitments to consider offsetting the residual emissions by using an entity that does carbon offsetting. So those are a quick canter through the sections of the protocol that for legal advisors, which is a lot of you on the call, and we're happy to answer any questions, and also we're very happy to receive any feedback that you have. Again, this will be individual to your organization and indeed to the individual cases that you have, but we would really encourage you strongly to adopt these wherever possible.
Thanks, Sarah. I will now quickly take you through the Green Protocol for Arbitrators. Now, the aim of this protocol is to provide individual arbitrators with practical guidance for minimizing their environmental impact, both during the course of proceedings as well as in their individual practice. This protocol is the most aligned with the Green Pledge and the guiding principles, as Lucy mentioned at the start. Originally, they were intended to be focused more towards arbitrators, so you'll find a lot of synergies there. One feature of this protocol is that it should be considered supplemental to the protocol on arbitral proceedings, which arbitrators are encouraged to consider adopting as part of the arbitrations which they oversee. So, of course, there is some duplication in terms of the measures, but one of the reasons that's one of the key commitments in this protocol is because, of course, the largest impact individual arbitrators can have is to encourage all parties in proceedings to adopt the sustainability measures in the protocol for arbitral proceedings. And in that way, they use their influence to expand the number of people that are taking steps to reduce their environmental impact. This protocol is divided also into a number of sections, with the initial commitment to reducing the environmental impact of arbitrators' individual practices. It includes a series of commitments and actions to be taken to reduce material waste during the course of proceedings. This covers measures relating to the reduction in printing to favoring electronic communications, which we've discussed, and ensuring that any printing that is done only where strictly necessary, in an environmentally friendly way, and is disposed of also in an environmentally responsible way. The protocol also includes a series of commitments that arbitrators can make during the conduct of proceedings and in hearings. As I just mentioned, the most significant of those commitments is to bring this protocol, as well as the protocol on arbitral proceedings, to the attention of co-arbitrators and parties, and to encourage their adoption. And of course, to use their influence to ensure that we're making the move towards electronic filing and e-bundling, and the use of shared technology platforms for the exchange and organization of materials. And alongside that, encouraging the use of telephone conferencing or video conferencing for both CMCs, preliminary hearings, and even in the hearings where appropriate. And then finally, as the others have mentioned before me, there are a series of recommendations in terms of commitments that arbitrators or changes that individual arbitrators can make to improve their own home working environment. So we're conscious that not all arbitrators will fall within the format of fitting within a law firm or an existing chambers. So there is some guidance there for those who are operating more in a sort of a lone wolf scenario. And then finally, of course, various commitments regarding offsetting residual carbon emissions. And here again, it's important to stress that the protocol is focused on making changes, behavioral changes to the way in which we work. So offsetting is not a solution, it is a measure of last resort that is encouraged just for those residual emissions. Now, as Lucy mentioned, we started our drafting work on these protocols at the very start of the pandemic. And in many ways, the silver lining of COVID is that the proposals that are included in these protocols are no longer groundbreaking for any of us. They're measures that we've all been required to take to ensure business continues as usual. So our hope here is that none of these measures will fill anyone with dread at the potential challenge of adopting them. So we do welcome general comments on this protocol, as well as whether there are any areas where we can go further now, because we've got our eyes very much on the future and implementing even more change than we've had to implement to date. In terms of specific feedback that we'd welcome on the protocol, one area which has been a subject of much discussion for us while we were drafting this concerned the correlation with the protocol for arbitral proceedings. So the recommendation here is for arbitrators to encourage the adoption of the protocol for arbitral proceedings. And the reason it's drafted the way that it is was to take into account comments we received from arbitrators that they often felt that they didn't necessarily have the power to require their co-arbitrators to adopt specific measures. What we'd like to hear from you is whether or not that view is more widely shared, or whether we can make a stronger commitment here. So, for example, include a requirement that arbitrators adopt the protocol on arbitral proceedings on any arbitration they're appointed on. Similarly, any feedback on the feasibility of the measures that are recommended herein regarding the use of shared platforms, e-bundling, electronic annotation, and of course the increased use of video and telephone conferencing throughout the conduct of proceedings is welcome. And with that, I will pass on to Kieran to talk to us about protocol on arbitral institutions.
Thank you so much. Hopefully you can all hear me, and I've unmuted myself, which is a good start.
Just to say, we may not have many representatives from institutions on the line today, but you all are users of institutions, so certainly the Arbitral Institution Protocol is relevant to you too, and certainly coming from an institution, I know how important buy-in from users, albeit arbitrators and counsel, and the broader commercial user base is. So it is also very relevant to you participating today. I just want to say very briefly, it's been an absolute pleasure being part of this group. Very inspiring to be involved in a committee that's doing something so meaningful. Thanks to Lucy and also the really hard-working members of this group. But with that, the aim of the protocol is really to provide institutions with practical guidance to minimize the environmental impact of their activities. Now, this protocol suggests, I suppose it's all-encompassing, and it suggests a number of different measures that can affect various aspects of institutional work. Obviously, case management, and that's what most institutions do, but it also includes references to those institutions that provide hearing services. It also talks about business development and conference organization, because I certainly know at HKIC we do a lot of that, and also internal operations. What we wanted here was one document that an institution could just go to, and perhaps if not all aspects are relevant to all institutions, they can certainly pick up on the case management part, that is. I know through the others that have spoken, and particularly Sarah, who talked about operations at law firms, that area has been covered, and I know that we have hearing services and the conference protocol coming up. So I'll really limit my comments to case management. So I think why including a protocol from an institution is important, not just because I'm on the committee and I'm at HKIAC, but as you all know, institutions have oversight over hundreds, if not thousands of cases. So institutions do have the ability to make a difference and to affect change on quite a large scale. Simply through the volume of cases that we see and the number of counsel and arbitrators that we have contact with on a daily basis. So it really was important, and I was delighted to get involved to present the institutional perspective when talking about how to really drive and implement change in the field of arbitration. I suppose what we're aiming for here is for case management measures that are appropriate and achievable. And also, we're keen to know whether these measures that are included, perhaps go too far, but better still that they can go further. And I think, as Mag mentioned, we started drafting last year, and so much has changed, and even our experiences of going virtual are so much better than they were a year ago. So I think certainly some of the suggestions in these protocols and in the one for institutions that relate to case management might be fairly obvious, and I think actually that's only a good thing because we can hopefully be pretty pleased with ourselves that we're already making steps that can make a difference. So when reading the protocol, a couple of points to think about. Certainly the measures themselves and the extent to which they should be implemented. And I think importantly for institutions, it's worth thinking about how these measures should be implemented. Is it through our internal practices alone? Maybe through the implementation of practice notes that are published online? And thirdly, whether amendments to rules actually need to be made. So I think, or perhaps a combination of all of the above, but keeping in mind how changes should be made in terms of institutional practice is probably key. So developments and changes in the case management work of institutions can't really be done, and this is coming from someone who's been at an institution that's gone through 2 rules revisions over the last 10 years. We don't really do things without certainly informing our users and the wider community, especially if it impacts how cases might be run. And we also really ideally like the majority of folks to be supportive of any changes. Institutions are fairly cautious creatures, I think, and we certainly can be innovative, but I think We like careful innovation, and what that really means is that we, and in this protocol, need to be sure that the changes are necessary and meaningful. That's easy in this case. We're not talking about complex consolidation. We're talking about saving paper and virtual hearings. So I think the buy-in on the principle is definitely there. But what's important for our users, including all of you that are on, is that you're on board with what that really means for your cases. Just a couple of examples of things that are included in the protocol that relate to case management. The first few examples are certainly things that we've all been doing and are easy to do if you're not. I mean, communicating by email, that's not even a thing anymore, but encouraging people to do that from the outset is important. We certainly still receive box files of annexes to notices of arbitration that we could actually receive by email. So even though it sounds obvious and we're doing it, there are times when that doesn't happen. So really encouraging that email communication and using online repositories for service of documents and document transfer. That's something, again, growing in popularity, fairly easy to implement, and that's a suggestion that's in the protocol. This is something I think that certainly institutions were very alive to last year, but making sure your rules include broad definitions of what a hearing can be, i.e. you can capture, it doesn't have to be an in-person hearing. Maybe empowering tribunals to determine how witnesses and experts can be examined, specifically empowering them to do that, and that can include, therefore, remote examination. And then internally maintaining electronic case files, so, not receiving those boxes full of annexes to notices of arbitration and filings. Going a little bit further, again, coming back to how some of these measures can be implemented, there's a suggestion that the use of technology should be included in institutional rules and certainly should be included in any case correspondence, but I use the word encourage. And also whether institutions should be offering up procedural, template procedural orders, for example, when they send the case file over to the tribunal that really do align with green practices, i.e. they make great reference to the model protocol that was spoken about earlier. And then can we go even further? So perhaps in rules, what we could be thinking about is that the default is virtual. We haven't included that in the protocol, but I think it's something that it would be great to have feedback on. And also, this is not a comprehensive list, but considering to what extent should appointments of arbitrators take into account any commentary or disclosure of an arbitrator's ability to run a proceeding in an environmentally friendly way. So I've just put a few examples out there of things that are obvious and that we're probably already doing. That always makes us feel better. Places we could go that we have included in the protocol, and then a couple of points perhaps that we could think about if we want to go further still. In terms of including institutions and requesting their specific feedback, we will also be writing out to institutions across the globe to get written feedback and including them in regional workshop sessions. But of course, do share your comments in the chat or later today, tonight, tomorrow, over the weekend, directly to me or to the email address that was provided earlier. One point to note, and it's really how I started, but institutions are reluctant to impose. We love when parties agree to things. We know they don't often, but when they do, that's great. So if we can get councils buy-in for these things and arbitrators to direct and feel comfortable doing that, that will also lead to really significant change. And I think what's been wonderful about this campaign is that we do have the support from council, from arbitrators, really from all of those that are involved. And I think if we're working together, then I think we really can make a meaningful change. So yeah, that's what I wanted to cover in terms of the institutional protocol. Thank you. I think I'm handing over to Reka now, who will talk about arbitration conferences and hearing venue providers. Thank you.
across jurisdictions. It's a pleasure to be here. Thanks to the Jones Day team, of course, to Lucy, and to my colleagues who have been drafting these protocols. So I'm closing us out today on conferences and venues. As the Executive Director of NIAC, I've seen lots of traffic in our space for both of these elements. And as you can see, of course, there's much carry through from one protocol to the next. Focus topics are repeated: printing, energy consumption, technology. Each list necessarily includes more items than may be operative at any one conference or venue, to really create a thoughtful process in the nascent stages of planning a conference or a venue as you take in bookings, perhaps. Common themes across both of these protocols and the others: how to reduce energy consumption, how to reduce waste, how to reduce the carbon footprint, and then how to focus on electronic and video communication, thereby avoiding unnecessary travel. Of course, as many have said, our community has indeed been resilient. We have pivoted in these times, and so much of this has become commonplace as we talk about remote, virtual, or digital. So looking specifically at the conferences protocol, this idea that let's begin to plan in remote in advance of the actual conference. Let's conduct some of the events using a virtual platform rather than in person, especially when there are multiple events involved. This hybrid approach, of course, we've already embraced, as I've said, in a pandemic setting, but it also is a way to embrace more people across more jurisdictions. In 2020, one of the benefits, perhaps, and acknowledging there may be limited benefits, is that we were able to host international arbitration weeks fully remote. We brought in more delegates that way, more perspectives, more diversification, and that is important to our practice as well. Of course, to utilize electronic conference materials with access to virtual platforms at check-in, and conscious of single-use items, right? Of course, mindful of public health and safety procedures, but let's consider the totality of the waste. Let's go for accurate head counts, for example, of food. Food waste is a big thing at conferences. Use local, stay local, travel responsibly. And of course, although a last resort, how can we offset? Can we, for example, incorporate a service activity as a community during our conferences? Candidly, it may be a really nice opportunity to leave the conference venue and get outside. Much needed, sunlight as well as we embrace our colleagues and plant some things, perhaps. Let's go ahead to the next protocol on venues. And here we are. These protocols speak to daily operations as we make plans for hearings. And as Karen highlighted, as we talk about institutions and we talk about venues, it's really something we want to encourage, but it goes over much easier if clients perhaps bring it to us. And so that's important. Not only can a venue implement, but parties can request implementation where it's possible. So it keeps these items top of mind. As we concretize these key considerations, we're looking to things like, how do you limit attendance to those necessary? How do we limit waste and keep it top of mind? Things as simple as on-demand stationery or BD materials. How do we stock recycled and recyclable paper, right, at the outset? And even perhaps to consider staff offsetting as a service activity. As we imbue our personal platforms with these protocols, I share that in New York, I'm delighted to report, as you may have seen in a recent GAR article, and a warm hello to our GAR colleagues on the line, that we're building out new space, and we're trying to take these protocols into consideration as we evaluate that. It's often easier to do it in a build-out phase, rather than when a venue is already established. How do we, for example, use natural light more and LED lights? Where can we use smart power cords, and also to encourage clients to actually power down and not just go into a sleep mode. So stay tuned on those developments. The truth is that NIAC, for example, cases often book with a 10-month lead time. And so that's a great time to begin to socialize the Green Protocol and talk about compliance if all parties have advance notice and if we can plan collaboratively. So as a quick reframe of the questions, we're asking you to consider, have you planned a conference or even attended as a delegate. We all have a role to play, right? And then also, have you booked or worked at a venue? And finally, how do you monitor success? That becomes critically important in truth as we talk about all of these. But I'll pause there and pass the mic back to the next slide, please.
To all of the presenters of this working group, and let me please reiterate that it has been an immense pleasure to work with each of in this case, women who are here on the screen with you today, of course, under the guidance of Lucy. So we are delighted now to be sharing the results of our work with you today. Now, unfortunately, our polls are not working, but what I would like to do very quickly is to read you the questions that we had for our last poll for your consideration, and we would love to hear your responses either in an email or in the chat if you're interested. So think about, have you ever attended a virtual hearing in your career? Have you switched your home or office workspace to a green energy provider? Have you attended a virtual arbitration conference or webinar since the pandemic began? Have you ever participated in a case where all submissions were provided in electronic form only? Have you ever offset your flights in the context of an arbitration before? And have you ever decided to hire a local court reporter or translator for an arbitration hearing rather than using one located in another jurisdiction? These are all some of the elements which come out of the protocols. Of course, there's very much more there, but we would love to hear whether you have already adopted any of the suggestions which are included in the protocols, because as people move towards these behaviors, we anticipate that already there may be some actors who are already implementing some of these in their daily practice. So now we'll move on to the question and answer session. We have one question in the Q&A box, but if there are others, please feel free to post now. The Q&A box is separate from the chat, but if you're having trouble, you can also post in the chat if you're unable to access the Q&A box. We have a first question from James Turner. How confident are you, and what analysis or research has been accessed or undertaken to reinforce that confidence that, for example, hosting electronic hearing bundles on a server for months and potentially longer is quote-unquote greener than printing bundles? That's a very important question, and I think Lucy would like to respond on that issue.
Yes, Shireen, let me jump in on that. It's a fantastic question, James. Thank you for posing it. Short answer is not overly confident, frankly. We are concerned about the digital footprint. It is a very, very complicated issue to wrap our arms around, as I know you know, James, and others on the call will know. We are working in due course, on my list, to get there to understand these very difficult issues. We have taken a deliberate we've made a deliberate choice in the campaign to keep the message very simple. So your question as to whether it's actually greener to print bundles and host documents on a server for a very long time is a difficult one to answer, but to communicate the very simple message that we're trying to get over, which is, as one of our speakers said, less waste, reduce waste. So we want people to be printing less. We want people to be thinking about how they can print in a more environmentally friendly way. In due course, I suspect that we will be able to issue some guidance in terms of reducing our digital footprint. There's an awful lot of information out there that I've started to look at in terms of sending attachments in different ways, limiting the number of recipients to emails, not sending two-word emails. So I know we all have a tendency to just send a quick thank you, cutting all that down. But we have held back that digital piece pretty deliberately because we don't want to overwhelm our audience. We want to make these steps they are quite prescriptive, as you have seen from the speakers today, but we want to make them simple and accessible to all. So essentially, I'm not giving you an answer there. I don't know the answer sufficiently yet, James, but watch this space.
Thank you, Lucy. And if I just might add one general point, we are intending, once the Green Protocols have been finalized, to include posts on the Greener Arbitration website and in blogs and just other forums to share the fact that to share specific means by which the various elements of the protocol can be adopted. So we are not intending to just put the protocol out there without further support or further guidance in their actual implementation. Of course, this will entail further research and further involvement from different stakeholders in the process. So we're not going to leave anyone hanging in terms of how they might actually make these suggestions a reality. Aside from the, I don't see any questions. I guess with that, the end of the session in 3 minutes, I will turn it over to Christine for brief closing remarks. But let me say first, very big thanks to everyone for logging on today. We have another session coming up on Wednesday of next week. It will be the same structure, but hopefully we'll get the polls to work by then. But please encourage your colleagues and friends to participate. We look forward to disseminating this information as widely as possible. And thank you so much to all of the panelists and to Lucy and Linda for participating today, and to all of the participants for attending. And with that, I will turn it over to Christine.
I think you've pretty much covered our closing points, but just to reiterate again, some of you may have signed up for both sessions, so it will be the same content at the next one. You're certainly welcome to join again, but I don't think it would be necessary. But please direct any of your colleagues or any contacts who may be interested to go and register today. There's still a few more days to register for next Wednesday's session. And then, as noted, we will be also implementing some regional discussions as well, so be on the lookout for that. And of course, as we've mentioned, at any point along the way, please email our protocols address. We'll follow up with an email so that you have this handy. And you're also welcome to contact any members of the working group individually, so feel free to reach out to us as well. And I think, we are in this consultation phase, but I hope that in addition to reviewing the items, that you also do try to go ahead and start implementing some of them. And I think once you do, you'll see how easy some of the changes are. And again, those that maybe require a bit more work, you can process in due time. But at least initially, the challenge for now would be to select a few and just go to town and start improving and reducing your carbon footprint. So with that, I thank you all for your time today. Thank you for joining us. Thanks to everyone on our panel, and we hope to hear from you soon with your feedback. Thanks all.